Good evening. Welcome to the People's University, the struggle for women's rights. And tonight we're going to talk about the Equal Rights Amendment. But before I introduce our presenter this evening, I just want to remind you that if you ask a question at any time really during the broadcast, you will have a chance to win this lovely radical tea towel featuring Ida B. Wells. That's tonight's gift. And also 2 tickets to the Heinz History Center, free passes to the Heinz Center. So we'll have 2 drawings at the end. And then next week, our guest will be Carrie Stone. We'll be talking about the Me Too movement, and you'll have the opportunity to win this women's suffrage poster from 1908, which is pretty cool, but it's also a tea towel. These radical tea towels are awesome. They have a great collection if you look at their website, but you can win a free one here tonight. So, as I said, we are going to talk about the Equal Rights Amendment, and our presenter this evening was the person who opened the series for us, and that is Anne Marie Lofaso. You all know her. And she is Arthur B. Hodges Professor of Law at West Virginia University College of Law, and she has been named WVU College of Law Professor of the Year, among many, many other things. And here she is, Anne Marie Lofaso.
Thank you so much, Sean. I really appreciate being here. Today's Constitution Day, and this is a real honor to present today. And I'll be presenting on the Equal Rights Amendment today. So what I wanted to do was to look at a little bit of review of things that we did in the opening presentation, just really quickly, so that we can put ourselves in the historical context, so we understand why the fight for equal rights was such a hard fight, why it hasn't been won, and what the problems are and obstacles. But maybe the battle hasn't been won, but other battles have been. And I hope that we can open that up for discussion and talk a little bit about that. So we're going to look at just really briefly a little bit about colonial women, really focusing on white women. You'll see why in a little bit. And then Abigail Adams, who challenges the founding fathers. And then we're going to look at the different waves of feminism and see that the fight for equal rights, the Equal Rights Amendment, is really part of the second wave feminism. I was born in 1965, so I'm a sort of a third wave feminist. And the fourth wave feminism is right now, is the students I have in the law school and that. So with that, let's look at the status of colonial women. I just wanted 2 slides on that, but we've talked about this before. I've given a couple of lectures on this before, but we know that married women could not own property. Widowed women could not own property unless they could own property unless they remarried. And upon marriage, women lost their identity. Now, of course, in the colonies, Black women were generally enslaved. And so this wasn't really, when we think about this, I think it's important to look at it also from a race perspective, and that much of this doesn't apply to Black women. I'll try to bring that out throughout the lecture tonight. Now, Blackstone was a man who lived in the 18th century, and he put together the commentaries on the laws of England, which is sort of a Whiggish history of England, insofar as it gives an optimistic view of how great the English Empire is and how wonderful it is. And he puts together all the laws in these commentaries. But the problem with it is that by the time he puts it together, it becomes really stale. In other words, the laws are starting to already change in England because we have industrialization. And so it's a really old-fashioned way of looking at things. But in any event, it does give us a snapshot of what people thought of many things at that time. And of course, why am I talking about England is because notwithstanding whatever your national origin is, our legal heritage is an Anglo heritage. So the idea is this idea of coverture, which we've talked about before, which is that by marriage, the husband and wife are one person in law. That is.
Emery,
Yeah.
I'm sorry to interrupt.
I'm sorry.
The slideshow isn't running.
It's not? Okay,
No.
let me change it. Okay.
Yeah.
Is it there now?
Now it is. Yeah. Yeah. You might want to go back to show the slides we missed. And yeah. Okay.
Okay, I'll do that.
I'm going away.
So we have this struggle, right? And then I showed you what the agenda was going to be, which was we're going to talk about colonial women, and then Abigail Adams and her challenge to the founders. Then we're going to look at the different waves of feminism. And first wave feminism is just going to be a very quick review of what we've already done in looking at really the 19th Amendment. And then we're going to go beyond that to the second wave of feminism, which is really the focus of tonight. And I'm also going to do a little bit of third wave feminism, which is the post-ERA era. Next week, you'll hear about the Me Too movement, which is really the fourth wave of feminism. And so let's just a couple of slides on colonial women. And I think what I was trying to make the point here is that I'm really focusing on white women and their status, because of course, most Black women in the colonies would have been enslaved. So they, not only could they not own property, they generally were property. So it would be a very different analysis. And that's not because I want to ignore them. It's I want to show you actually that we need to look at this from also a race lens. So it's actually the opposite. I want to see this from both lenses, both a gender and a race lens. So we know that married women could not own property. Widowed women could own property unless they remarried. And then, but upon marriage, women lost their identity, and that's called coverture. And that's a legal status that we get from, and we understand in part because of Blackstone and his incorporation or his codification of the commentaries, or he's actually an academic, so he's not really codifying, he's not a legislature, but he compiles, I guess it's better to say he compiles the laws of England. And like I said, the laws of England at that point were already becoming stale or no longer in use, because with the industrialization of England, Great Britain, the United Kingdom, what we find is that the laws are going to rapidly change in response to these economic changes. But at the same time, Blackstone's important because our Supreme Court will often cite to Blackstone, notwithstanding the fact that this is no longer the law in England many times. And this does give us an idea of what the legal status of colonial women were, colonial white women. So by marriage, the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into that of the husband, under whose wing, protection, and cover she performs everything, and is therefore called in our law, or in French, a femme couverte. And it's under this, she's under the protection and influence of her husband or her baron or her lord, and her condition during marriage is called her coverture. So you can see when a woman gets married, she loses all her rights. That would be, my name is Dr. Anne Marie Lofaso, or Professor Anne Marie Lofaso. I'm married to a man named James Heiko, so I would be Mrs. James Heiko, so I would lose my title, I would lose my first name, I lose my last name, I lose everything, right? Because I become one with my husband, and we are one legal unit in which his identity is precedent over mine. It takes precedent over mine. So in comes Abigail Adams, who comes from a family that's very is very famous in the colonies. And she is also very, very bright and educated. And of course, we know her husband is the second president of the United States, one of our founding fathers, one of the authors of the Declaration of Independence. He's on the committee that, of course, Thomas Jefferson actually writes it, but he's on the committee. And She writes a letter. They're famous for these letters that they wrote back and forth with each other. And she writes, and this is a very famous quote, and probably most of you have heard of it. I long to hear that you have declared an independency. And by the way, in the new code of laws, which I suppose it will be necessary for you to make, I desire you would remember the ladies and be more generous and favorable to them than your ancestors. This is in March 31st, 1776. So we're really on the brink of independence. And of course, there's already been some battles in the Boston area. So really the war has already begun. So we have the Declaration of Independence in 1776. And here is Thomas Jefferson, John Adams, and Benjamin Franklin. And note, of course, another very famous phrase from here is, we hold these truths to be self-evident that all men are created equal, that they are endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. Now remember, if man is the protector of woman, if the husband is the protector of wife and children, then of course they're thinking in terms of this household, so they're not even thinking about women. And we also know in that same Declaration of Independence, they talk about slavery. So this is an often criticized part of the Declaration of Independence, but it's also an ideal. So some people are very critical of this in the sense that they said, well, I wasn't included, which of course meant most of us in the United States today would not have been included, including many white men who are propertyless would not necessarily be included in this. But at the same time, I'm an optimist, and I like to see this as something that going toward a more perfect union, that this is our ideal that we are going to try to get to. And so we look now, when we get to the United States Constitution, the preamble says, we the people. It doesn't say about men. It says, we the people of the United States, in order to form a more perfect union, to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, to ordain and establish this Constitution of the United States of America. So on this day in 1787, this document is finished. It's written, ratified the following year, less than a year later. And what's really important here, I think, or part of it is, it's we the people. Interestingly, also, if you look at the text of the original Constitution, it actually doesn't reference gender or race, although clearly race is implicit in the Fugitive Slave Clause and the 3/5 Clause. But it's not, the word slave is not used. So no person held to service or labor in one state under the laws thereof, escaping into another, shall in consequence of any law or regulation therein be discharged from such service or labor, but shall be delivered upon a claim of the party to whom such service or labor may be due. I just want to point out that if you look at this, it was very important to the Constitution Convention, the founders of our Constitution, the writers of our Constitution, to put in the phrase under the laws thereof, because they wanted to distance themselves if there was any federal right of people, white people, to own slaves, of any person in the United States to actually own slaves, that this would be under state law. And that's why that phrase is in there. And then, of course, you have the 3/5 Clause, which is a compromise with the southern states, because most of the people in the southern states are Black slaves and they want more representation. So this was a way of getting them to agree to this type of union. So it's subtle, but it's not so subtle. So with that, we have this first wave feminism, which I'm going to do a really quick recap of my first lecture during this series. And what we're going to look at, we already looked at this first obstacle to civil rights, which is coverture. But there's also the cult of domesticity, which I'm going to do really quickly for those of you who weren't able to come to that lecture. The ultimate prize here is not just getting property rights for women, but was getting the right to vote. So the cult of domesticity was this idea that women was this ideal of what womanhood was. And in part, it was put forward as a response to the fact that men and women were no longer working on farms. So it's this economic these economic changes that are happening, where men and women are no longer working together side by side, that there was a lot of family economic structure, that we were moving from that to a more industrialized nation, and also to the building of infrastructure that became man's work. Men were doing that, not women. So there had to be this idea of what was the proper role for women in this new society. And of course, this was coming out of some old ideas also, which we discussed last time. But it really comes to a cult in the 19th century. And the idea was that to be a true woman, you were pious, you had piety, purity, submission, and domesticity. And of course, you were white. And just very quickly, piety was that women were naturally religious and had a naturally pious mind. Men didn't. And so it was women that would bring men to religion and to the moral life, that women must be pure before marriage. That meant they must be virgins, and that it was better for a woman to die than to give up her virginity before marriage. And that the best day of her life was giving her virginity, her most prized possession, to her husband. That a woman who didn't do this was a fallen woman. She was not even a woman. She wasn't worthy of the celestial company of her sex, her own sex. And then we also talked about this idea of submission, that women must submit to the authority of their husbands, who were the doers and the shakers, and they must be submissive, and that this was an order that was fixed in heaven. It was divinely ordained, and that men were superior to women. And of course, women were to be domestic. The true dignity and beauty of the female character was to consist in a right understanding of and faithful and cheerful performance of social and family duties. And this was also, the Bible was used to support this idea. And women who did not live up to these virtues were a threat to society and to the United States as we knew it. So there would be disorder at Armageddon, etc. And indeed, social reform was viewed as an attack on the pure woman doctrine. And we talked last time about bloomers. Bloomers are like what people wore to ride horses. They were slacks. And this is a cartoon from this. My dear Jessie, what on earth do you have that bicycle suit on for? She says, why? To wear, of course. And Gertrude says, but you haven't got a bicycle. And Jessie says, no, but I've got a sewing machine. Yes, I can put it together. So it's a funny yet somewhat sexist cartoon in a different way, though it's also a feminist cartoon. So I think it's really interesting. And so the idea here is that women, if they wore bloomers, what was going to happen? They were going to fall into immorality, because you can't wear slacks. I mean, this is horrible. So part of this idea was that man's sphere was the public sphere, politics, business, military, and woman's sphere was family in safety and virtue, the church. And just another case we went over last time. We went over a lot more cases last time, but this was one I just wanted to highlight, as I am a lawyer, is in Bradwell versus the state. You can see how important and influential this cult of domesticity is, because in this case that goes to the Supreme Court says that Illinois, when it refused to license Mrs. Bradwell to practice law, so wouldn't let her give her a license to practice law in the state of Illinois, even though she met every requirement except that she was a woman. The reasoning was because man is or should be woman's protector and defender. The natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life. The constitution of the family organization, which is founded in the divine ordinance as well as in the nature of things, indicates this domestic sphere as that which properly belongs to the domain and functions of womanhood. And it continues. I didn't read this all last time, but I do want to read it this time because I think it's important in understanding when we go forward. The harmony, not to say identity, of interest and views which belong or should belong to the family institution is repugnant to the idea of a woman adopting a distinct and independent career from that of her husband. So firmly fixed was this sentiment in the founders of the common law that it became a maxim of that system of jurisprudence that a woman had no legal existence separate from her husband, who was regarded as her head and representative in the social state, and notwithstanding some recent modifications of the civil status, many of the special rules of law flowing from and dependent upon this cardinal principle still exist in full force in most states. One of these is that a married woman is incapable, without her husband's consent, of making contracts which shall be binding on him or her. This very incapacity was one circumstance which the Supreme Court of Illinois deemed important in rendering a married woman incompetent fully to perform the duties and trusts that belong to the office of an attorney and counselor. So and the picture I have here is of an invisible woman. A woman can't be in that sphere. She's invisible. She must be in the private sphere. So it's with that we get now the ultimate prize, which is not only getting property rights, because you can't vote in many states without property rights, but is actually getting the right to vote. And this fight is really a twofold strategy, maybe even a threefold strategy, but predominantly a twofold strategy of state by state and constitutional amendment. Though there's also a third strategy, which is the equal protection, extension of the equal protection clause, which I'm going to talk about and which becomes much more important with the Equal Rights Amendment. And so, as we discussed last time also, we have this women's rights movement, which starts before 1848 with people like Elizabeth Cady Stanton and Lucretia Mott. And when they meet in London for an anti-slavery conference, and they're not admitted because they're women, they say, we need to fix this. So that starts the push to have, many years later, several years later, the first women's convention, which is the Seneca Convention, which is the first women's rights convention in 1848. I want you to notice, though, that there are no first of all, only women come to the first day, and they're all white women. The second day allows men, but there is at least one black man in attendance, and that's Frederick Douglass. But it's very important to understand that this was white women were often excluding black women. Now, I'm not suggesting, this is open for debate and this is open for discussion, that means these white women were terrible or anything like that. What I'm saying is that there are different levels, as we say in critical theory. There are different levels of consciousness. And so, of course, men are trying to extend rights to other men, and they might be thinking of, say, a black man needs a right of a man. So a very sort of progressive white man might be thinking in terms of black men getting the vote. And a white woman might be thinking, well, I should get the vote. If a black man's going to get the vote, why can't I, as a white woman, get the vote? But then she's not necessarily thinking neither the white man, a black man, and maybe even white women. Some white women were not even thinking about black women. Now, there were black women that were heavily involved in this, okay? And they were very important. Sojourner Truth, people like that. But they were often forgotten. They were invisible. So there's another layer of invisibility. And until we start to reconcile that and understand that, I think that's a problem. And one thing I wanted to say is, if you look at one thing I'm really excited about is, of course, all of us have a right to vote now, and I'm going to vote. And I'm very excited, and everyone should be able to vote for whomever they want. But one thing I'm very excited about is that one of the people on the ticket is Kamala Harris. And I say that because Kamala Harris is actually exactly my height and my weight. She's 5'2" and 130 pounds. So for me, there's never been a person on the ticket as short as that. No one. So for me, it says, I grew up thinking there's no way I could ever be president of the United States. Oh, by the way, we were also born within a year of each other. We're about the same age. And so for me, I see a woman, and I see a short woman when I see her. And I'm telling you, it was very empowering for me. Now, I can vote for whomever I want, but just to have her there, now it's 2020, it's a long time waiting. That's important and significant. Okay, so this is part of the speech that Elizabeth Cady Stanton gave on this. And this is just a landmark. So here's the Civil War, of course, interrupts all this. And then the part of the post-Civil War strategy was actually to get, first and most importantly, is to get the 13th Amendment. So to eradicate slavery. And of course, we do pass the 13th Amendment. There's the 14th Amendment with its equal protection and due process and other things. And there's also the 15th Amendment, which is to get the Black person the vote, which means the Black man. Some women in this group were upset about that, and some were okay with that. Just like if you look at the recent strategy of gay rights, some gay rights advocates were pushing for gay rights, and others, the LGBTQ community, were pushing for, no, we're not going to go for gay rights unless we also get transgender rights at the same time. And there was a split in that movement, just like there was a split here. And some women said, I'm not going to support your movement, men of color, for racial equality, until we get at the same time gender equality. And it turned out that there was a push for racial equality before gender equality. Again, we can talk about whether that was a good idea, a bad idea, what that means for values, but that is historically accurate. So we have this three-part strategy that we're going to see happen again for the Equal Rights Amendment. The first is to pressure states to grant the right to vote, the Equal Protection Clause, and this constitutional amendment. And then we see that the states, the Equal Rights Amendment, sorry, let me go back. The Equal Protection Clause, which I'm going to talk about in a little bit, is almost stuck. It's dead on arrival for women. It's not extended at all in the beginning for women. We'll talk about that in a minute. So let's just look at the other two. What we see is that there's a push by states, and it's successful. By the way, the exact same strategy the gay rights movement used. Very successful. And finally, we get the 19th Amendment in 1920. So this now brings us to, that's our constitutional amendment. And that means that it's now federalized, which means no state, doesn't matter if they pass this or not. So now everyone gets that. And just note on the 32-cent stamp, it is a white woman voting. All right. This brings us to now the context of second wave feminism. Now, we know 1920, we just finished World War I. There's the Roaring 20s, everyone's happy. Then we go into the Depression. And what's really important here is that you have, there was immediately a push for equal rights. That push is also divided primarily along class lines, where more elite women really want certain things. Specifically, they want an equal rights amendment, and working class women want socioeconomic rights in the workplace. So once again, there is a three-part strategy: extend the Equal Protection Clause, piecemeal repeal and revision of existing state and federal laws, and constitutional amendments. I'm going to tell you right now, the Equal Protection Clause does not get extended to women until 1972. And when it's Ruth Bader Ginsburg who does it, and she does it by showing how men, it's a brilliant strategy, how men were harmed by the law in certain instances. And then once you get that precedent, it applies to sex, and now it's going to have to apply to women when they are treated worse. Because of course, there are laws that actually were more protective of women than they were of men. So Ruth Bader Ginsburg is the person who comes up with that strategy. And she's like the Thurgood Marshall of gender, or Thurgood Marshall is he came before she did, so we'll keep it that way. Now, in 1971, there's a really famous law review article in the Yale Law Journal, and it basically says we really need the ERA. Why? We need the ERA because piecemeal repeal and revision is going to take forever and we'll never get it done. And there's never been, the Equal Protection Clause never been extended to women. Of course, a year later, it is extended to women. Okay, here's the Equal Protection Clause. It's the red clause in the 14th Amendment. You have the Citizenship Clause, the Privileges and Immunities Clause, the Due Process Clause, and the Equal Protection Clause. So the first one just says all persons born or naturalized in the United States and subject to the jurisdiction there are citizens of the United States and of the state wherein they reside. So I reside in West Virginia, so I am both a citizen, and I was born here. I was born in New York, actually. So I am currently a citizen of both West Virginia and of the United States. Okay? Privileges and immunities. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So that's a limit on state power. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So this is a Civil War amendment, as we talked about earlier. What it had in mind was race, not gender. But 100 years later, we're finally applying it to gender, which is very significant. But remember, the Equal Rights Amendment was actually already being pushed in 1923, and no one had any hope of getting the Equal Rights Amendment, getting the Equal Protection Clause being applied to women. Now, of course, like any good lawyer, like I teach my students, you always want to have multiple fronts of attack. So people are keeping up all these attack fronts. And we just talked about this, that what the Equal Protection Clause was there for. Okay. So the proposed Equal Rights Amendment is that equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have the power to enforce by appropriate legislation the provisions of this article, and this amendment shall take effect 2 years after the date of ratification. So I just want you to understand how this constitutional amendment procedure works. And there's a couple of ways you can get a constitutional amendment, but one way is the Congress could have 2/3 votes of both houses. That means the House of Representatives and the Senate shall propose amendments to the Constitution. And then you could get ratification by the legislatures of 3/4 of the states, or by convention. So in 1923 would be a different number, but let's just say by 1972, when it finally passes, which we're going to talk about in a second, that means you need 75% of the 50 states, and that's 38 states. So let's look at this history now of the Equal Rights Amendment, which we have in 1916, the National Women's Party forms, and Alice Paul, who's the founder of that, she writes the ERA, and she introduces it in 1923 on the 75th anniversary of Seneca Falls. And between the 1920s and the 1960s, like we discussed earlier, support for this really divided along class lines, where working class women were really much more focused on practical matters in their view. And more women of a higher either social class or economic class were thinking along the terms to the right to vote. Now, query whether working class women should have also been thinking about that, because with the right to vote, they can change legislation and that would help them with these rights. But remember, in the 20s and 30s, the 40s, the 50s even, how were women getting economic rights was partially through labor unions, which wasn't really yes, you had the National Labor Relations Act, but it was very much an economic movement. So this was probably a very wise strategy for working class women. In any event, Congress introduces the ERA every year between 1923 and 1970, and it only passes once. In the meantime, remember, we have these different strategies. So in 1963, the Equal Pay Act passes, and 1964, Title VII passes. So this is some really good labor legislation. And finally, the ERA passes Congress in 1972, which means it has to go to the states now for ratification. And with a March 1979 deadline, and I think that's the only amendment that Congress has ever given a deadline to. 35 states pass it by 1977, so they only need 3 more states. The deadline's extended to 1982, and it stalls. And in comes Phyllis Schlafly, who I think I spelled her name wrong. Sorry about that. I think it's only 1 F. So she's born into a family where her mother's the breadwinner. Her father was part of the structural unemployed during the Depression, but she is privileged enough to attend college, and she ends up graduating from Washington University in St. Louis. She then goes to Radcliffe, which is the Harvard. It's the same thing as Harvard, same professors, but it's called Radcliffe because if you were a woman back then, you could not go to Harvard. And she gets her master's in government, which is Harvard's, that's what they call political science. She then gets a JD, a law degree in 1978 from Washington University. She's a Republican. She's pro-life, or if you prefer, anti-choice. She's pro-segregation. She ran for office once and lost. She ran for a congressional seat in Illinois in 1970. She lost, and she is the great opponent of the ERA. Her big concerns, and I got to tell you, I remember this because I was born in 1965. So by the time she's on the scene, I'm a little girl, and I remember being really scared of the ERA because I heard it was going to remove all these really important benefits that women had. And most importantly was military service, that the exemption to military service. So I was really afraid because remember also you have the Vietnam War. It's a very unpopular war. So my view of her, and I'm no expert on her. I'd love to hear what you guys think. I'm sure you know more than I do about Phyllis Schlafly. And that movie's coming out. If it hasn't already, I can't wait to see it about her. But I really believe, was instilling fear in women about that somehow all of a sudden we were going to lose all of these rights that we did have. So you can see this is the state ratification process. And what you see is we actually currently have 38 states that have ratified, but there's a little problem. First of all, the 3 states that make to get it to 38 ratified it in the last 3 or 4 years. So in 2017, we got Nevada. In Illinois, 2018, we got Illinois, and then we get Virginia just earlier this year. The other problem is that 4 states rescinded it shortly after they ratified. This begs the question, do states have the power to rescind? There's nothing in the Constitution. While the Constitution gives states the power to ratify, but they do not give the power to rescind. And indeed, in other cases, the way they have counted whether or not there were sufficient votes for ratification, they've always counted votes, even of states that even if they've rescinded. So you say, okay, then what's the problem? The other problem is, well, there was this deadline. And some people think you can't put a deadline either. So some people actually think that we should test this in court right now, and whether that we might have this. I have my doubts that it would pass. This is really interesting. I think it would be better to just redo all of this. And I don't understand why people would vote against this, but who knows? I saying that I don't understand why they would doesn't mean I think that they wouldn't. I actually think it probably has a slim chance of passing, but I don't understand what the opposition is. This is Phyllis Schlafly with Ronald Reagan. And if you know your political history, of course, when Ronald Reagan came in by 1980, he brings in this conservatism that replays into, to some extent, the cult of domesticity. And we are starting to get, by the end of the Reagan era, we are getting into the third wave of feminism. Now, the second wave feminists who fought for the ERA, and they're the first wave of women that are a lot in the workplace. I mean, of course, there were women in the workplace way before that. And when I say the workplace, of course, women have always worked. They've worked in the house. They've worked on the farm. I'm talking about in jobs that are paid, in jobs that were traditionally male jobs. Those are your second wave feminists. And part of what was important to them was this idea that men and women are completely equal. There are no differences. So you get intellectually a lot of debate because, of course, there's one glaring difference between men and women. And that is that only women can give birth and breastfeed. Now, I'm going to put a little caveat on that, because if you're a transgender person, a transgender male, and you keep your uterus. So a transgender male is a person who's born with female private parts, a uterus, a vagina, etc. And then, but they identify as being male. If that person doesn't have the sex change operation, he identifies as a male. So he's called a transgender male, but he could still have a child. So I made the mistake once with a bunch of young people of saying, well, of course, only women can have children, meaning biological women with uteruses. And it was not pleasant to be around. So I always make that caveat. I understand that. I'm talking about, this is complicated by the fact that we now have a consciousness of transgender, okay? So I want to add that in, and we can talk about it if you want. But there is a difference between, at least biologically, that there is one glaring difference, which is breastfeeding and birth. And but does that mean there are other differences? And does that really matter legally? Should it matter legally? And if it does matter legally, how should it matter? So that brings us into this post-ERA, which has a lot, even during the ERA era and post-ERA, we see a lot of labor rights, which is my field, is predominantly labor rights. What I want to explain here is that women were able to get some rights during what was called the Lochner period of the early 20th century, which is both before they got the right to vote and somewhat after, when men couldn't, except for coal miners, get this protective legislation because they were viewed as more frail. So of course you didn't want women and children working in coal mines or working late at night. And so child labor and female labor got more protections, which was great, except that's in part why the Equal Protection Clause was not being extended to women. And that created some rights that women had that men didn't. So men could tough it out and have these horrible working conditions that women were not allowed to have. Another really famous case was that women couldn't work as a bartender unless their father or husband owned it, because of course that would create problems because men are drinking, and when men drink, there's vice, and that if there's a woman behind the bar, there's going to be lots of vice. And so since men can't control themselves, women have to bear the burden of men not being able to control themselves. Another problem is there are many women that want to serve the country in a combat role, and they weren't allowed. But we do see in World War II, there were plenty of women that while they were excluded from combat, they saw combat. And what you see is in this overlapping of this time is you do see this more and more economic quality of women in the workforce while the ERA is stalling. And part of it is, once again, women were able to ride on the back of race, like, for example, Title VII. Title VII was going to pass at that point. And it was politically, it had to pass. There was no doubt at that point. And so by adding sex there, women were able to get that. But they were not able to get equal rights. I think they might have had it not been for Phyllis Schlafly. And of course, there's also these constitutional amendments. I want to say, Supreme Court constitutional decisions. I want to say something about the Due Process Clause here. And whether or not you're pro-choice, pro-life, whichever you want to call it, if women can control their reproductive cycles, then they can have more equality in the workplace. Part of that is the right to contraception. And that, in 1965, the Supreme Court invalidates a law in Connecticut, a state law forbidding persons from using contraceptions. They said that's unconstitutional. So what you have here is, and that's, by the way, that's under this, what's called the Substantive Due Process Clause. So that's under remember the Due Process Clause is part of the 14th Amendment that states that we shall not deny someone the right to life, liberty, or property without due process. Many people thought that was only procedural, and then they said, no, there's actually a right of privacy in there. That right of privacy then gets extended to women that in abortion, which says that in Roe versus Wade, and then in later cases, in particular cases versus Planned Parenthood, that states can't regulate a woman's medical decision on abortion until viability. And viability is about 20 weeks. And after that, then the states can restrict. Otherwise, any restrictions before that are unconstitutional. So if your state, like West Virginia right now, has restrictions, but they're unconstitutional, they can't be enforced. A woman can have an abortion in West Virginia, although it's almost impossible to have. And from what I've been told, as one, I have never had an abortion. Two, I'm 54, so I wouldn't need an abortion at this point in my life if I wanted one anyway. So I don't know for sure, but I've been told it's nearly impossible to get one anyway, de facto. But de jure, you cannot deny a woman an abortion in the first 20 weeks, even though we do have a law right now that was passed that does that. Okay, so this is another timeline of many other Supreme Court cases. A few of them, like, for example, that I think are important, that was part of, again, the strategy of getting more rights for women, of knocking down to get equal rights. Because remember, the Equal Rights Amendment is not working, right? It's been, by 1982, it's gone, right? So what are you going to do? You got to get the Equal Protection Clause. You got to have state legislation. You got to repeal state law. You got to repeal other federal laws. So what do? They get Title VII. But then everything's always 2 steps forward, 1 step backwards. So here's the 2 steps forward was Title VII. 1 step backwards is the Supreme Court interprets Title VII as not applying to pregnant women. Because being pregnant is not, if you discriminate against a pregnant woman, you're not discriminating against women. You're discriminating between pregnant people and non-pregnant people. Totally ridiculous argument. So Congress comes in and Congress says, no, we don't like that. So Congress fixes that problem. Another case is Price Waterhouse versus Hopkins. And in that case, women are the Supreme Court says that you cannot deny promotions to women based on your ideas of an ideal woman. In that case, Ann Hopkins was going up for partner, and she was great, apparently. She was really good. She deserved it. If she were a man, she would have gotten it. But the partner said she didn't wear enough lipstick, and she was sort of a little bit too much like a man. And so they denied her the promotion. They said, no, you cannot stereotype. So what we're seeing is that line of cases really has allowed that women can't be discriminated against in the workplace because either that they're too feminine or too masculine. And you see this, you can also see that there's the sexual harassment laws. And they start with women being raped in the workplace. And then they start realizing, and this is when women are coming into the workplace, some men, obviously not all men, it's a minority of men, but they're men who are raping women. They are propositioning women. They're saying, if you don't have sex with me, that you will, I will make sure you're fired or you will go nowhere. So in some cases, the woman under coercion agrees. In other cases, she's actually raped. So there's no consent. And what we see is by this time, Ruth Bader Ginsburg is on the Supreme Court, and we see really great advances for women on the judicial front. So the chipping away of these laws at the state and the federal level. Look, but the ERA is stalled, and the ERA doesn't really get to a lot of attention until the Me Too movement, which Carrie will talk. Carrie, who's a good friend of mine, and she's wonderful. She'll be talking to you next week. There's other SCOTUS cases that I think are really interesting that are about whether or not, here, this is a good one, like Dothard versus Rawlingson, which I teach in my employment law classes, which is that women are female prison guards you can discriminate against them in prisons where men are the prisoners and they've been convicted of rape and other violent crimes. I always prefer that in these cases, that rather than doing it on gender, that you do it on, are you strong enough? And a lot of cases are now doing that instead. So you could have men who would not be good in those situations, and you could have women, and it probably is going to be more women than men, assuming that you do need a certain amount of strength. I'm just going to make that assumption. So let's say that is a good assumption. But it seems to me, rather than using gender as a proxy for that, why not use what you're really concerned about, which is the ability to defend yourself? Of course, the Family Medical Leave Act. Now, that's for men and for women, but women are going to be the first to really take advantage of that. By the way, I'm sure you know that there was a marital rape exception, which, by the way, Phyllis Shapfly was in favor of, which is, as one of my friends says, that the marital rape exception basically is when a woman says, I do, on her wedding day, she says, I do on demand. And that means a man who's her husband can never rape her. All of them were removed by 1993. That means when I was in law school, because I graduated in 91, there were still marital rape statutes on the book. But now, no, none of them are on the book anymore. So there is this piecemeal legislation working, and at the same time, you're getting this ERA, more interest in the ERA. So we'll see where that goes. I'm going to end here. I want to thank Sean so much. He's so wonderful. I love working with him. He's brilliant. He's so creative. He works so hard, and he does such amazing things to do this. I love his programming. So thank you so much, Sean. Thank you for everyone who helped produce this event. There's so many invisible people that do this. I don't know their names, but I just want you to know how appreciative I am. I always enjoy doing this. So I'm going to stop sharing now, and I hope I can take some questions. So I am seeing a question that says, historically, men have been threatened by empowered women. Why? I would have, I'm not a sociologist, but part of me being a labor expert, we do dabble in sociology. So with a caveat that I do not have a PhD in sociology, but my guess is that if you are, it's our culture. So I think many less men are threatened by empowered women today because we raise them differently. But if you're raised to believe that you are to protect women and then you're not able to because these women don't need your help or they don't want your help, then you may feel threatened that you're not a real man. So there's also something called masculinities theory that talks about how men themselves are also victims of this, the kind of the opposite of the cult of domesticity, which is this almost toxic, it can be even toxic masculinity, but not just that, but that if a man is not a football player, really athletic, macho, a certain, drinking his beer, that somehow he's not all of a man. So I think that's really a part of what is going on. And yes, we should all agree about Sean. And Sean certainly is a man who is, I think, not threatened by women and empowered women. So what is SCOTUS? Oh, I'm so sorry. SCOTUS is Supreme Court of the United States. So you know how you say POTUS, which is President of the United States, and you say FLOTUS, which is First Lady of the United States, and SCOTUS is Supreme Court of the United States. So I sometimes use that as a shorthand for the United States Supreme Court. I apologize for that. Hi, Barb. Love seeing you. I never thought about height equality and what we can rise to become. We are the same height, and although I'm a little older and weigh a little less, but now I too have new heights to reach for. Yes, yes. And hopefully I will continue to lose weight and I'll weigh even less. Okay. But right now I'm about 130 pounds. So I aspire to be you, Barb. Okay. Hi, Aaron. What rights did a woman who never married have? Okay. So depending on what it was, but at pretty early, women, if they were a child, they didn't have many rights. But if they were unmarried, they actually did at some point they were able to do a lot of these things like property. I didn't want to go into it to kind of confuse it. So at some point they were getting rights. It was really married women that were losing these things by the middle 19th century. And what I mean by that is that there was a chipping away at the lack of rights that women had. And again, I want to stress mostly white women. Many of them were educated to read because, of course, there was this idea that women need to read the Bible, but not necessarily to write. And so there was some emphasis on education, which is good, but it was for the purpose of piety. And what I really believe is that people should be part authors of their own life and be able to decide for themselves what kind of life they want to lead. And hopefully it will be a good life, one that's moral and one that's contributing to society. But what morality is many, many things. And it doesn't have to be a religious life or a Christian versus a Jewish versus a Muslim life versus a Buddhist life. It should be what people want. That's my personal view. But in any event, that was what was going on, was that unmarried women did have some rights, certainly more than married women. Other questions? Why would states be threatened by ratifying the ERA? How is it in this day and age that all states have not ratified this amendment? It's really beyond me. I don't understand because, one thing I forgot to say is one of the problems is still the Equal Protection Clause, because unlike race under the Equal Protection Clause, which gets strict scrutiny, which means if you're going to make a classification based on race, the court is going to really strictly look at it to determine whether it's constitutional or not. On gender, it's only intermediate scrutiny. And the only reason we have that is probably because of Ruth Bader Ginsburg. So what would happen, I think, if you got the ERA is you'd say strict scrutiny. Now, some things might pass strict scrutiny in gender, possibly. So, for example, we might still want to have some bathrooms that are based on gender. There might be reasons for doing certain things that would come under strict scrutiny. But what I really think the problem is a fake news phenomena, which is that if you tell people and you're a person of authority, oh, you better not do the ERA because you know what's going to happen. Every woman's going to be drafted. Well, men aren't even drafted. So how are women going to be drafted? Okay. Or, oh, you don't want to do the ERA because you know what's going to happen. You're going to have to share bathrooms. Well, first of all, for example, at the law school, when we have shared bathrooms, there's locks. And if you have a gendered bathroom, there aren't locks, right? But if you go to a ungendered bathroom, a unisex bathroom, you have locks, only one person at a time in those bathrooms. So there's ways to do these things, but I think it's about instilling fear and playing on people's fears. So let's just say you're a woman that you were raised to believe that your life's duty was to have children, and you like that. So that's what you want to do. That's how you're going to actualize your potential. And that's going to be how you want to be part author of your life. I think that's wonderful personally. And my mother was like that. Although my mother wasn't completely happy, she wanted to be a lawyer, but that's another story. But she did raise 7 children. Now, if you tell that woman, oh, if you get the ERA, you're going to have to go to work, that could be very threatening to someone. So I think it's playing on cultural values and saying that this is what's going to happen, which that's not what's going to happen, but people are afraid. I just remember like when I was a 7-year-old and I was afraid, and I can remember believing these things. So I think that's part of what's going on. Other questions? Okay. And I aspire, oh, thank you very much. Mutual Admiration Society. Would you like to speculate about the relationship between the executive and judicial branches at the moment? I have a lot of faith in the judicial branch in this way. Once someone is appointed for life, they do tend to become less political. And you'll see that in every single wave of new judges, that they start to become a little more independent and they change. Now, I don't know, there are some instances where Trump has appointed some judges that don't even seem to be qualified. There's a lot of very qualified judges right now that Trump did put on the bench. They're very conservative, no doubt, but they're very qualified. I really believe that judges after a while tend to become less political. So for example, a lot of conservative judges put on by, say, Reagan and Bush too, not so much Bush 1 and Clinton, they were a little more moderate in who they picked as judges, but Reagan and Bush 2 put a lot of conservative judges on. And when I was litigating a lot before the courts of appeals, I noticed that after they were on for a couple of years, and I would say, hey, look, this employer is doing this bad thing. And they'd say, in the beginning, go, oh, the employer's allowed to do that. And then they start seeing these cases over and over again. They realize, oh, the employer's lying in this case, because they'd see over and over again the same excuses. They had to do this. And so I found that judges often start to realize that, oh, maybe workers are not always wrong, even though I was pro-business my whole life, and that maybe there's really a balancing going on here. And same thing for, I think, some progressive judges that will think, maybe the employer doesn't always discriminate, and that this really is not a case of discrimination. So I have a lot of hope for judges, and I hope that the rumors about some of these so-called unqualified judges are wrong, but I haven't looked into them that much. I also think that judges will have to excuse themselves if they are looking at something that Trump did and they were involved in that. And I think we are seeing that. And remember, the SCOTUS, Supreme Court of the United States, will have the final say. And we have seen that John Roberts has been very independent, and even Gorsuch has been quite independent. Less so with Kavanaugh, but we'll see. We'll see what happens. And, you know, I always say that the law is a game of chess. And when you think you're checkmated, there's always another move. And each side will constantly make moves. And maybe that's the greatness of our country, that we will be able to like the team of rivals. We won't always agree. I certainly disagree with a lot of what the judges do, of what some judges do. But in the end, we come to a better union. Maybe, but this is the problem. Maybe it's too slow for some of us. And I think this is what, when I talked to some of my gay students, they were very upset because they felt that, you know, why do I have to wait to marry when I love this person? Now, of course, they have the right to marry now. And that was very compelling to me. Because why do they have to wait when they just love someone? That was a really hard thing for me to listen to. So, and now we're getting into jurisprudence. So that's my long-winded answer to your question. We can talk for hours about that. But is there a statute of limitations on the validity of a state's ratification of ERA in terms of counting toward the total number of states needed for national ratification? Okay, so that's like a yes and no. The Congress put in a statute of limitations. And so that would mean that all these states, except for the last 3, would have to redo it. Or even the last 3, because they did it afterwards. So we have to be all over again. So, but some people say that wasn't valid, and Congress wasn't allowed to do that. And so that would have to be fought at the level of the United States Supreme Court would ultimately have to decide that. So that was my question. Is it better to give that to the Supreme Court, which may or may not be particularly sympathetic to the ERA, although it shouldn't matter whether it's the ERA or something else, or should the states just start all over again, or do both? So that's the real question that I think only SCOTUS can answer. There is some good, well, anyway, that's enough. Do transgender males give up their rights as women? So a transgender male is someone who is a woman at birth or female at birth that identifies as male. So my understanding right now is that they would be male at that point. Now, it really is going to depend, because we don't have an actual constitutional amendment on this. It's all piecemeal legislation. It would have to be done piecemeal. So for Title VII purposes, there was a case called Bostock, which was really a bunch of cases that the Supreme Court just came down on. And my prediction was, and I happened to be right this time, was that this court, because it was conservative and textualist, would side with transgendered people and gay people, and would say that when Title VII that said that you cannot discriminate on the basis of sex, because that is clear in the text, that meant sexual orientation and transgender. Because when you discriminate because of sexual orientation and discriminate because of transgender status, it is because of sex. And that is exactly what the majority of the court, including Gorsuch, who wrote the opinion, who is a very conservative man, said. So I think that in that case, you would have all the rights of a person in the workplace, whether you're a man or a woman, and it would be done that way. But it's hard to answer that question in the abstract, because it really depends on each statute, and there's still piecemeal legislation going on. So it's hard to really answer that question other than to say this is how you'd analyze it. Other questions? I'm a little...
I'm breaking in because I think that was the last question. We had a lot of favorable comments.
Oh, lovely. That's good.
Yeah.
That's always good.
Yeah. And now we're going to give stuff away.
Oh, excellent. Okay, I'll clap for people.
All right. So first will be the Ida B. Wells Radical Tea Towel. So I'm mixing up the names. And I'm going to pick this one. Carolyn Ziegler, you have one.
Congratulations, Carolyn.
Ida B. Wells, which I coveted myself, but I can't win. I'm not eligible. But that's very nice. And here are the two Heinz history passes for, I can't read my own writing. Barb Lewine. Barb.
Yay, Barb!
Heinz history passes. And I will mail these gifts out to you both this week. Thank you all for, and Anne-Marie, thank you for all your kind words and for doing 2 programs for us. I think you've done 4 or 5 total now. So you're like a veteran of the People's University and the Labor History Symposium for Walls. So we thank you.
I hope you'll invite me back.
Of course we will. You are
Excellent.
beloved.
Excellent.
So thank you. And thanks everyone who attended tonight. And again, Carrie Stone next week, Tuesday at noon. Cheryl Ryan Harshman will be looking at her studio. She's an artist, in addition to being a great writer. And she'll show you how she does her clay prints and things like that. So it'll be cool. All right. See you all next week.
Bye, everyone.
Yay.